Right, so this evening we're looking at enforcement of trust. Yesterday I introduced the concept of what a trust is and basically how to express a trust. We looked at the fact that we're talking about private trusts specifically rather than any other type of trusts, such as a statutory or public trust. We don't really delve in those. That's more for the government, and we don't want to have any third parties interfering in our private affairs. We also ended last night in how we'll go about expressing the relationship. Relationship was obviously very key to the heart of trust matters. And hopefully, if there's anything that you learned yesterday, was we need to define our relationships and be very aware and privy of our relationships in this commercial world in which we live. And we discussed yesterday, also as a recap, about the trust scenario. We defined the three relationships or roles of a trust, which is the settlor, which is the beneficiary, and also the trustee. And we looked briefly at the roles of each party: the settlor, the trustee, and the beneficiary. The settlor is the creator of the trust. He's the one that puts property into trust, and we call that property the res. Okay, and then he assigns a trustee. It could be himself or another party to maintain and administrate the property for the benefit of the beneficiary, and the beneficiary enjoys the use of that property. So that was what we looked at yesterday very briefly. I also really discussed in detail as to the basic historical developments, which we're going to go into a lot more this evening. We also broke down in no uncertain terms that you are the settlor. The settlor is the real man. The settlor is the creator. The settlor has the power, holds the keys, and he writes the law. It's his law in that trust when he declares the trust or makes a declaration of trust. It's his law or her law, which, as he is the king, and it's the king who makes a declaration, what he says goes as far as that trust is concerned. And it's for us to understand our role as a settlor and to really embrace the concept in our minds that pretty much we can do what we want to do and say what we want to say and see it done, and expect that the office of trustee shall be carried out. So tonight we're going to look at enforcement, and the big question is, well, what is enforcement? We've looked at trust, which is fine, but what's enforcement? What's the big deal? The only way I can really explain enforcement in the very basic terms is compelling those who are in charge or responsible for the trust to perform. If they fail to perform or they're lacking in their duty, then someone has to enforce or compel the trust to perform. And so it's really looking a lot deeper into the law of trusts, and I will be introducing to you the jurisdiction, a different jurisdiction of law or body of law called equity. Has anyone heard of the term before? Equity. If you just type in a Y on your keyboard, that'd be awesome. Or if you haven't, that's not a problem, just to help me gauge where the group's at. So we're looking at equity. This evening I'm going to introduce that as a concept and as another distinct body of law so people understand where we're coming from. Okay, so brilliant, we've got some decent responses there, that's fine. So I'm going to break that down for you. I will also look at if statutes and acts pertain to what we call as the common law. And don't get confused when I say common law now. Please don't get confused with the old English type of common law. When we refer to the common law, I'm talking about the law of the land as it is today. What is the law in place? The common law in place. which is governed by statutes and acts and admiralty. Maybe 100 years ago, or even longer than that, we had English common law, which is fine, which is obviously not the same as statutes and acts. But today, when I say the common law, I'm just talking about what is the law in place today, and we refer to that as the common law. All right, does everyone understand what I'm saying there? Just so that there's no confusion. Now, so I'm saying if statutes and acts pertain to common law, then maxims pertain to equity. So we're going to introduce enforcement. I can't obviously go into it in too much depth this evening. There's so much to it, but hopefully by the time we finish this evening, you'd have a more of a gist of what it's all about. So introduction to equity and enforcement. Now I'm going to be doing a bit of reading this evening from various texts because, as I always say, I don't like to have things in the words of Richard. Unless I'm trying to explain or define something. I prefer to let the definitions preferably come out of the so-called or proverbial horse's mouth. So I'm going to be reading, first of all, a transcript from a judge. His name was Lord Justice Turner, and it was a case called Milroy versus Lord, a very famous case in Chancery and equity circles, but I just wanted to give you an idea, because some people may ask the question, well, you might go to court or maybe challenged by somebody to say, well, we don't accept a trust as a form of payment, and you need to be aware of your rights to say, well, it's every man's right to form a trust. So I'm going to read out the transcript from this famous case, and we're going to get started from this basis. And it's everything to do with private express trust, which is awesome. So, Milroy versus Lord, it says, in order to render a voluntary settlement, and all that is just a payment, in other words. In order to render a voluntary settlement valid and effectual, the settlor must have done everything which, according to the nature of the property comprised in the settlement, was necessary to be done in order to transfer the property and render the settlement binding upon him. He may, of course, do this by actually transferring the property to the persons for whom he intends to provide, and the provision will be then effectual. So in other words, just as you go to Tesco's every day, you can just transfer the money straight away to the cashier. So you have every right to do that. So it's a direct settlement, as he says here, or actual transfer of property to the persons for whom he intends to provide. And this is that provision will then be effectual or made real. And it says, and it will be equally effectual if he transfers the property to a trustee for the purposes of the settlement, or declares that he himself holds it in trust for those purposes. And if the property be personal, the trust may, as I apprehend, be declared either in writing or by parole, which is verbal. But in order to render the settlement binding, one or other of these modes must, as I understand the law of this court, be resorted to, for there is no equity in this court to perfect an imperfect gift. And the cases go further to this context, that if the settlement is intended to be effectuated by one of the modes to which I have referred, the court will give effect to it by applying another of those modes. Okay, if it is intended to take effect by transfer, the court will not hold the intended transfer to operate as a declaration of trust, for then every imperfect instrument would be made effectual by being converted into a perfect trust. Now, let me just break that down if it sounded a bit too techie and legal jargon. Effectively, what Lord Justice Turner was saying is that every man, woman has the right to either make a settlement directly, i.e. just call it a straightforward payment, as we do at the moment, all right? Or he can make a settlement by way of a trust, okay? In other words, you can declare yourself to be trustee, or you could assign someone else to be a trustee as a settlor, all right, for someone else's benefit. You have every right to do that. You have a choice. So that don't let anybody tell you, this is a law justice now from the senior courts in well-known case law stating that every man has the right to either make a payment in trust or directly. I hope everyone understands that. Now, he went on to say that if it's not done properly, then equity can't come to your aid because it doesn't look at imperfect gifts to be equal to a trust in any way, shape or form. So now, even though yesterday I basically, and it is true, it's trust law that parties in the trust need not know that they're involved in the trust, it's still important to make sure that whatever property you are depositing into trust as a settlor, as the one who creates, okay, and disposes of property, must create the trust properly. There is a set procedure. Now I'm going to introduce this concept before I go into enforcement in any more detail, because if you can't prove a trust, you have none. I'll repeat, if you are unable to prove a trust exists as a settlor of a private trust, you do not have a trust. I'm going to say it one more time. I'm not lacking of words to say. I'm not repeating myself for boredom. I'm trying to dig this deep into the fibers of your being, into your memory. If anything, you can write it on the inside of your eyelids. If you do not have, or you're not able to prove a trust, you have none. And if you have no trust, then the game's over. All right? You cannot allow third parties to have discretion on your private affairs. You cannot allow courts, judges, or any other third party to get involved in your private affairs and mess up your plans, because it could be disastrous for you. So you have to make sure you do things properly. All right? Now, the case that I quoted was Milroy versus Lord. Milroy versus Lord. Okay? That's 1862, this case. Milroy versus Lord. Just Google it. All right? There's plenty of cases like this that backs up everything I'm saying to you this evening. So we're just introducing enforcement. So I'm saying, first of all, if you have no trust, if you can't prove trust, you have none. All right? If you're unable to prove a trust, you have none. I'm sorry to repeat myself, but it is absolutely it's vitally important. I'll write it down. If you are unable to prove a trust, you have none. So it bears now the question, or the questions now deserve to be asked: how do I prove a trust? So I may have mentioned yesterday, you may have heard me mention yesterday, that there are certain rules that we need to adopt. Now, for those who learn from our brothers over the pond, so to speak, in the USA, they have different ways of proving a trust, which will not hold water in this country. So you have to understand the UK law and how the courts operate to prove a trust, and then you apply it for your own private affairs, for your private trust. So UK law have a very powerful rule, and it's called, you may have heard of it before, the rule of certainties. Okay, now I'm going to read something else to you now from another judge regarding the trust and proving the trust. So we're going to, spare me 1 second. Basically, the rule of three certainties, I'm just going to write it down and I'll get the text to read for you. Number one, you must have what we call certainty of intention, which I'm going to explain shortly. Number 2, certainty of objects. Has anyone heard of all this before, or is this new to you? I don't know if I'm preaching to the converted, or if this is something that is completely new. And then number 3, certainty of subject matter. All right, now this is vitally important. So let me read this out to you now. Just spare me 2 seconds. I'm just going to read it out to you so you can see. Now, the judge, the famous case is Knight versus Knight, and I'm going to read it out for you now. It says that to create a valid trust, I'm reading here from the book I mentioned yesterday, which is by Professor Alastair Hudson, Equity and Trust, 6th edition. That's Alastair Hudson, Equity and Trusts. I'll just repeat because apparently the sound went. The book that I'm reading from is from Alastair Hudson, Professor Alastair Hudson, Equity and Trusts, okay, 6th edition. The main principles underlying this area of law are as follows, okay? This is certainty in creation of express trust, which is what we're dealing with in the private. So, to create a valid trust, the terms of that trust must be sufficiently certain. There are 3 forms of certainty which the courts require. There's certainty of intention to create a trust, certainty of the identity of the subject matter comprising the trust fund, and certainty of the beneficiaries or the objects of the trust or power in question. Now, A, the settlor's intention to create a trust as opposed to something else must be clear. The settlor's intention to create a trust must be clear. All right, I have to really emphasize this. You cannot be in 2 modes of thinking when you're about to express a trust. Else they'll see right through you, and they'll give them the right to discern your private affairs. You have to make sure your certainty or your intentions are extremely exact and deliberate. Okay, so I'll read it again. The settlor's intention to create a trust as opposed to something else must be clear. There is no requirement to use a specific form of words when dealing with trust over property. All right, other than land. There's a specific way to deal with land. But everything else, there's no particular words you must use. The court will be prepared to infer an intention to create a trust from the circumstances and the parties' conduct. The court will be prepared to infer intention to create a trust from the circumstances and the parties' conduct. B, the trust fund must be identifiable. The trust fund, the res, must be identifiable. A trust in which the trust property is mixed with other property so that it is impossible to identify precisely which property is held on trust will be invalid. Do not commingle your trust funds, okay? Keep your relationships specific, certain, and special. Do not commingle. All right? Which we talked about yesterday. The trust fund must be a special form, must be set apart, specific for that use and for that purpose and that alone. So in other words, don't mix your apples with your oranges. All right. It says here that however, exceptionally, it may be that where the property is intangible property, that's one that you cannot touch, taste, or feel. So where the property is intangible property made up of identical units such as ordinary shares of the same class, for example, it may not be necessary to segregate the trust property from other property. I'll explain that shortly. This exception is doubted by many academics. And C, it says that to identify the beneficiaries, it is first necessary to identify the nature of the power which is being exercised in relation to fiduciary mere powers and in relation to discretionary trust. It is required that it is possible to say of any person claiming to be a beneficiary that that person is or is not a member of the class of beneficiaries. Some exceptional cases have taken the view that the trust may be valid where it is possible to say that a substantial number of people do or do not fall within the class of beneficiaries, which I'll explain that shortly. So let me break it down for you in further capacity. I'm going to read something else here for you. Three certainties. It says here that English law has a great affection for certainty. All right, judges are concerned that the law promotes certainty in contracts, trusts, and other dealings between persons. In terms of the trust specifically, the judge's concern is that the settlor makes her intention sufficiently certain. All right, the settlor makes her intention sufficiently certain so that the court will be able to direct the trustees how to act if there are problems with the administration of the trust. Now, I'm not too concerned about the court in that respect, but the point I'm trying to highlight is you must be very clear. So we're going to just show you a kind of a brief overview of how we would express certainty. Now, so in terms of intention, in terms of objects, and also in terms of your where are we? Subject matter. Now, let me explain this in further details. Your intent is very important. When we were talking about yesterday about trust being construed, remember that word? All right, constructive trust. It's pretty much is what is happening against you at the moment. So a relationship has been inferred or construed. Then effectively what is going on, as far as you're aware, or as far as I'm aware, is that that someone's acting in the capacity of unconscious. Well, let me start again. They're not being honest. Unconscionability. All right, they are not being honest. There's lack of integrity. So because of this, if you're going to be the settlor, your intent has to be very, very specific indeed. So when we express a trust, you're going to have to prove or cover your tracks to show that you had every intention to create a trust in the first place. All right. Now, there's a question here. Please validate what you mean by commingling. I think I might have answered the question, but just to clarify, I don't know if I haven't answered it yet. Yesterday, I mentioned very briefly about the commingle. So if you have a general bank account, all right, a general bank account, you would be paying your gas, you'd be paying your electricity, you know, your rent or mortgage or whatever it is. Pretty much everything comes out of this one account generally, okay? Whereas if you have, say, a special account for number one Acacia Avenue. All right, so basically, and only to cover for damage to that house, for example, then the only monies that would be in that bank account would be a fund to pay for damages. So if you were low on cash and decided that you're going to dip into this special fund to do the shopping, you violated the special account terms. So in other words, there's a commingle because you're using it for other purposes besides its specific one to cover damages to this special property. All right, so I don't know if I explained. So if it's not special, if it's not dedicated, then it's general, and if it's general, then there's a commingle taking place. All right, there's lots of things happening, so it can't be used for the purposes of a trust because it's not identifiable. It's not identifiable. It's not specific. All right, so I hope I explained that enough there. So another question is, I may be the only one, but I understand that you're saying regarding the trust. up to a point, but where I'm confused is if someone does not know they are in a trust, why am I creating one? Well, at the point right now, I'm trying to tell you is that you're in a trust relationship and you've never known it until now. But trust relationships are being made against you all the time, and they don't have to tell you that you're in a trust relationship, because the law of trust states that no party needs to know they're in a trust relationship. All right. So if you flip it on its script, obviously, if you're going to create a trust for the purpose of settling or extinguishing debts, then yes, certain parties will need to know that they're in a trust relationship. That's fair enough, because you are now expressing the relationship rather than making the relationship one of a constructive nature, which is an act of fiction. It's in their world. All right. So now you know that they don't have to tell you that you're in a trust relationship. It's your responsibility to have your trust eyes opened to see when they're trying to construe a relationship which is not going to be positive or conducive for your benefit. So that's why I'm trying to make the point out that no one needs to know, no party needs to be aware that they're in a trust. It also may be a situation where you have correctly expressed a trust and the trustees are saying, well, I've never received any documentation, I don't agree to be a trustee. Well, that's their problem. If you did everything correctly and you can prove it, whether they receive the paperwork or not doesn't negate the fact that they're trustees, and doesn't negate the fact that a trust is in place, because the law of trust says that the parties don't need to know. But doesn't mean that you shouldn't do what you're supposed to do. So it's a twofold argument. All right. So if I have a dozen properties, what would I need to do a dozen trust funds? It depends on what is the overall intention. That's the point. It depends on what your intention is to do. What is the purpose of the trust in the first place? Now, normally we just say, because this is just covering the basics of enforcement, but normally your intention is always to create a trust for the benefit of the beneficiaries. And pretty much you've covered every angle there. However, to answer your question, if you have one big portfolio with 12 properties, with one bank account, yeah, with all rent going into one bank account, and you assign a trustee to manage just those 12 properties with the one fund, with the one bank account, and as long as you can prove, or the trustee can prove, that he hasn't dipped into it to cover his shopping in Tesco's for his girlfriend or something like that, that violates the trust declaration that you're going to make, then yes, you can have all 12 properties in one trust. That's not a problem, as long as it's specific, special, and peculiar. But it may be something a bit more pedantic that you want to get sorted out, where it has to be done on a per property basis. So it just depends on what it is you're trying to do, effectively. All right. I hope that answers that question, and I hope everyone's. I don't know if that's answered your question, Lawrence, but hopefully that should be okay. So getting back now to certainty of intention, so we can move on. If you're as a settlor, when you declare, make sure you state that you just make it so that no one can argue with you. You have an intention, and that's to create a trust, and you're creating a trust to benefit the beneficiaries. All right. Now we're going to case law and all that stuff on the course. That's fine, which supports your argument. We're going to the structures of what we do, like creating memorandums and deeds and such, so on and so forth, in order to establish your intention without any shadow of a doubt that the law cannot construe something else. So we use the principle of notices to notice the parties, to make them aware of their, well, not to make them aware of their rights, but to make them aware that they have rights, and it's for them to go and find out what their rights are. But the fact that you've noticed them, you're acting in an equitable fashion, and so you're doing the right thing. All right, so that's the certainty of intention, and there's case law to support that. There's also, when we're talking about the certainty of subject matter, the subject matter is a res, and you have to make sure that certain rules have been complied with, all right, so sensitive subject matter, which is the res, the property. Now, the basic things you need to understand about that is, again, I've been harping on about it from yesterday and today. It must be have a special use, all right, for a singular purpose normally, right, solely for the trust itself, all right, not and it has to be deposited into the trust. So, in other words, you can't have, there must be proof of delivery. There must be acknowledgement in one way, shape or form, okay, of receipt for the use of trust. Now, the basis of that would be, for example, if I have a pen and I say, you know, Nana, hold this pen for me, please. And if my son asks that, you know, if my son ever needs a pen, I'm going to send him to you, and you'll just let him use that pen. Here's some cash, so if the ink runs out, just buy, you know, refill the ink, and then allow my son to use the pen whenever he wants to. I've just expressed the trust. Nana's a trustee, my son's a beneficiary, and I said that the pen is the res. But now I've got to be a bit more pedantic about it, because it's not just any old pen. Let's say that this pen happens to be a pen with the brand called Edding, and let's just say it has a serial number, X5123, okay, and it happens to be the color green. All right, so now I've made it very specific. So therefore, if anyone tries to swap it around, then the title number would have been different. Something would have changed. Maybe the quality and class of ink would have been different, etc. So therefore, there's no certainty of subject matter. But now I've expressed quite clearly the pen, then it's in trust. The trust has its use. The trust knows the title number of that property, the value, the amount, and its usage. And when you declare it as a settlor, obviously you're going to have other bits and pieces involved as well. Okay, so who must it be acknowledged by? Who must provide a receipt? The trustees are the ones who need to be in receipt of it. Now, there's different ways that we'll teach you in terms of proving receipt of it or proving delivery. But effectively, it must be done so. Okay. Now, the main thing is for a trust to be constituted, for a trust to be alive or vested, in other words, then the settlor must do his job and physically transfer property in the hands of the trustee. When it's in the hands of the trustee, then effectively the property is in trust. All right. So an acknowledgement could just be a declaration by you saying that you have done this on such and such a date. It could be the fact that you've used special delivery services. And by the way, the word special delivery is private. Okay. So it's very important you understand that, whereas recorded is a general. So you may want to be sending your instruments using special delivery. You've got a tracking number. You can track the fact that it's been signed for and received, and then that is that's decent enough evidence to prove that it's been delivered. In other words, it's left your hands, and someone else is in receipt of it, and it's been identified that they're in receipt of it. Okay, isn't proof of delivery and not received the same thing? Exactly. That's right. So that's what we're trying to say. So once that's happened, then you know the trust is now vested. You may want to use other means of expressing that via way of public notice and other means that we teach on the course that makes it watertight, that the trust is in place and no one can argue with you in any way, shape or form, because you've done what you're supposed to do and you've covered your tracks along the way, especially because you're expressing the trust. there's no room for manoeuvre. There's no room for second guessing your actions. So that's vitally important. And then obviously for certainty of objects, then yes, the beneficiaries must be named. And the capacity in which they operate. So if it's that they must enjoy they have full use of the property. So just like yesterday we talked about the Queen, allows her son to use the phantom roller. That's perfectly fine. Now obviously all of the peculiar parts of the phantom roller, like the VIN number, the colour, the date of registration, etc., would have been documented in her declaration of trust, which is fair enough. But in terms of the powers of the beneficiary, she would say, well, my son has the right to use it anytime he wants to. He does not have to pay any bills towards it. He does not have to pay any petrol fees, etc. He only has full use and to drive the car. So therefore, that's the powers now being defined. And then the trustee's powers would also be defined in your trust document when you declare. And that's all it is. And then therefore, you can prove using those 3 rules, and you'd have case law to support all of that, etc. There's no time to go into all of that tonight. So we'll be here for many hours, but we go through that in very fine detail on the course, so that you are armed with tools to now, when you have to go in the litigation process, prove the trust exists. And pretty much once you've got the rules of 3 certainties, you're there. You prove the trust, and once you prove the trust, it's downhill. Because once a trust exists, the argument now flips not to, well, have you paid or not, but, well, why have the trustees not paid? And so the argument now is the trustees are in breach, as opposed to you have not fulfilled your duty. Because if I go back to how I started off with what Lord Justice Turner says, every man has the right to make a settlement in trust or directly. And so if you've done it in trust and you can prove the trust exists, then you have paid as far as you're concerned. Or in other words, the trust should have made the payment on your behalf as a beneficiary. So that's the argument, and they can't argue with you because you've got their laws telling you the rules. So they can't be saying to you, well, now this is an American thing, or there's no, if they write to you saying there's no legal basis, they're absolutely correct. There is no legal basis. You're operating from the jurisprudence of law or equity now, as we say. So then we're going to move sharply into enforcement. So is there any questions around that? Is there any confusion around that? Or what if the trustee returns the res to the settlor? It doesn't matter. If a trustee decides that he wants to return the res, and you've done everything else that you're supposed to do, because, as I said, ignorance of the law is no excuse. Now, this is a general context, but effectively, a trustee has to disclaim. And if he doesn't disclaim, he has accepted. Now, it depends on who you've assigned to be the trustee. For starters, you've got to choose your trustees wisely. If you're just going to choose some Joe Bloggs off the street, then yeah, he can say, no, I don't want to be a trustee, and he can return the goods. So you may have to find a different trustee. But the way we teach, we're going to find trustees who cannot disclaim. They cannot do so. It's against their job description, and that's something that you're going to use to your advantage. The trust that I've expressed, I've not had anyone return any documents back to me before. So if it's done properly, then I don't see why they should be sending it, unless the trustees that we've nominated are not competent to do so, because they're telling you they're not competent to operate as a trustee, which may be the right thing in certain capacity, so you find somebody else to do the job. Simple. Is there a timescale within which proof of transfer by public notice must be made? Well, yesterday when we talked about the notice of interest and the statement of interest, typically I'd say within 14 to 21 days, if we're making a notice of interest, i.e. you, for example, just to recap about the notice of interest, you have full rights and titles to the phantom roller, okay? Full rights, title and interest to the phantom roller. So that's your NOI, or your notice of interest. Now, you could make action immediately. If you don't hear something, you could give it 14 days. I would say no longer than 21 days before you have to then prove your allegation. Yeah, I hope that answers the question. Is there time, like, can you give an example of a trustee you have nominated? Solicitors make good trustees, and they hate receiving these documents. Right, so always have a solicitor. They're the ones who's trying to make her life a misery. So give them a taste of their own medicine. They don't understand equity, which we're going to discuss in a few minutes. And by law, they can't disclaim. By default, they're public trustees. So that's typically you use solicitors amongst others. Yeah. So I hope that answers the question. So we're going to move on now to, basically that's how we prove a trust, and using the rules of certainty. If proof of transfer is done within 21 days, say privately to the trustee but not publicly, would this be problematic? Okay, we teach about in the course about the doctrine of notice. There's different types of notice. There's actual notice. There's implied notice. And then there's constructive notice. So from what the question you've asked me, you would have fulfilled one of these three. And any of these three are perfectly fine, depending on what you've done. But pretty much actual notice is you directly notice them. Implied notice means, well, if you're talking to Joe Bloggs and Joe Bloggs nominates a solicitor called, Bills and Co., and you sent Bills and Co. a notice, well, by implication, Joe Bloggs has been noticed as well. All right? And then constructive notice would be like a public notice. It's been construed. The fact that I've noticed the public, well, you should be aware. So your question, one of the three would have been satisfied. I try to make sure we fulfill at least two of the three in our processes. All right? I'll put it to you like this. Just regarding the doctrine of notice. There's a well-known case called Barclays Bank versus O'Brien. And Lord Brown Wilkinson says that the doctrine of notice is at the heart of equity, in that notice of, or in terms of constructive trust, knowledge of another's rights will preclude a defendant from seeking to defeat that person's rights. Yeah? So I'll read it again. I'm just trying to find a better... Yeah, so it says there, so Barclays Bank versus O'Brien, it's a case concerning the rights of co-owners to set aside mortgages, examined later in this chapter, which I'm reading from the same book from Alistair Hudson. It says, in that decision, Lord Brown Wilkinson asserted that the doctrine of notice is at the heart of equity, in that notice of another's rights will preclude a defendant, okay, from seeking to defeat that person's rights. All right. So, in other words, once you've noticed once you've noticed somebody that they have rights, you can't use a defense that you're ignorant of what's going on. But judges, solicitors, the whole lot will try to trick you and say, well, just because you notice someone doesn't mean they have to do it. Well, you're absolutely right. But you have noticed them, and they have the right to find out what their rights are. And if they fail to do so, then they have waived their rights full stop. ignorance of the law is no excuse. It's as simple as that. You don't have to tell them what their rights are. You just need to let them know that they have rights, and it may be of their interest to go and find out what they need to go and do. Okay, so, but a lot that, is gone. We deal with, it's a 2-day course, the basic one anyway, from 10 a.m. to 10 p.m. So you can imagine there's a lot of stuff we have to go through over 2 days, and we cover it in a lot of detail. Okay, so let's move on. Hopefully that's answered all the questions. Now, right, so I'm going to read some information here about equity and common law, because this is a good precursor to build up for enforcement of your trust. Now you can prove a trust, you can enforce it. All right, so it's vitally important to understand that proving a trust is vitally important. Creating one, yep. So do it in a way that you can prove it. Always start with the end in mind. As how I was taught, you start with step 10 before you start step 1. Just know how to play how to fight. So I want to read some text here. This is from Gary Watt's book, Equity and Trust. Gary Watt, I think, is probably one of the strongest proponents of equity that I've come across in a long time. And I'll just, he starts off with a biblical quote. He says here that, "Then shalt thou understand righteousness and judgment and equity." And that's from the book of Proverbs 2, verse 9. But he says here, the term equity can be used to describe a form of social fairness or a branch of morality or even an aspect of divine justice. But in the context of modern legal studies, the term equity connotes the law's internal capacity to depart from its general rules in the interest of better justice in particular cases. Okay, English lawyers have largely succeeded in their efforts to turn equity into something as regular and as general as law, but it still retains a flavour of its non-legal origins. So when we use the word legal, please don't confuse that to be lawful. They're two complete, distinct, different words. Okay, legality is not lawfulness. All right, legality could be something doing something completely immoral and incorrect, but it's still legally right. Doesn't make it morally correct, right? Where lawfulness operates in morality. Yeah, the best way for me to put it is legality looks at the letter of the law, whereas lawfulness looks at the spirit of the law, the heart of your intentions. So was someone acting unconscionably towards you? And the definition of unconscionability is if I go to the shop and I buy a sweet or an item that costs £10, and I give £20 expecting change, okay, and the shopkeeper gives me my £10 and I leave, then that's fine. If he gives me £20 by mistake and I leave, and I realise that I've just pocketed an extra £10. If I don't go back to that shop and say, "Sorry, mate, you gave me £10 extra money," who's acted unconscionably? Who has acted with an immoral attitude towards the shopkeeper? Can anyone just type the answer for me, please? Did you understand the question? Right, I have acted unconscionably, yeah, towards the shopkeeper because I have knowingly pocketed an extra £10 and I have not gone back and I've decided not to give it back to him. So I've acted unconscionably. In other words, it's not a natural act to be deceptive. Yeah, I've not acted consciously towards this person. I've acted unconscionably. All right, it's deceptive. Right, so the one who keeps the 20 quid is acted unconscionably. So you can see now that most of your relationships in this debt commercial world, especially how money creation and all that stuff, has been unconscionably towards you. I don't know if you can agree with that or not. All right, and because we're in a fiction, it's all unconscionability. So equity will correct that, but you have to build your case. All right, so this is where we're driving towards now. To enforce means you have to prove unconscionable nature towards you. An unconscionable character has taken place. Yeah, and unconscionable conduct has taken place towards you, and you have to now correct that record, right? But you have to prove it, because he who makes a claim must also prove, which we'll discuss more about tomorrow. But to enforce, so we're going to go into it in more details now. So I'm going to start here. So it says, the major means by which equity in law maintains a connection with its legal origins is the language of unconscionability. Equity in law is still concerned to prevent unconscionable assertion of general rights and powers. I repeat, this is a law book I'm reading, by the way, okay? So it says, equity in law is still concerned to prevent unconscionable assertion of general legal rights and powers. It's there to prevent it from happening. All right? In other words, where justice actually takes place. The word unconscionable has lost its connection to morality, and the courts try to use it as precisely as possible in ways which vary from context to context, but it reminds us of equity's ecclesiastic origins, okay, biblical origins, and reminds us that equity is a broader idea than the quite narrow legal version of the concept might suggest. Language such as unconscionability sits somewhat uncomfortably in modern law, but that it is a good thing for keeping the law realistically and appropriately humble about its capacity to cover every possible case by means of general rules. The language of unconscionability is highly effective at keeping the general rules open to just exceptions in particular cases and in particular kinds of case. A brief overview of the history is essential to understanding the modern law of equity and trust. We will see that elements of equity in English law can be traced as far back as Aristotle. But now it will suffice to say that the legal idea of equity was developed in England in the Middle Ages by a senior clergyman called a chancellor, who originally acted as the king's private counsellor. Okay? His task was to ensure the general common law, which was enforced in the king's name. Okay? And that was applied with justice in individual cases. Equity was therefore a way of exercising a royal prerogative of mercy, which was designed to ensure that the king's conscience was clear before God. The Chancellor eventually became the head of his own court, known as the Court of Chancery, as we know it today, and it was here that equity developed as a branch of law distinct from, and at times in competition with, the common law. I will repeat that for you, okay? The Chancellor eventually became the head of his own court, known as the Court of Chancery, and it was here that equity developed as a branch of law distinctively, right? Distinct from, and at times in competition with, common law. I hope alarm bells are starting to ring here. There are two branches of law, and most people only know about one, okay? You've got the common law, which is attacking you, trying to rob you, taking away your goods, okay? It's what we call in rem proceedings. In other words, it's always attaching itself to your things and not to you, all right? And then you have what we call chancery, which is the jurisprudence or the body of law which governs equity in the UK courts, all right, which deals with the person directly. The trustee who doesn't perform can effectively be in contempt of court and go to prison. All right, so you need to understand how powerful trusts are. What does the word equity mean? It cannot mean trust if the book is called Equity and Trust. Equity is fairness. That's probably the best way I can put equity. Equity is fairness. In the legal context, I'm actually defining equity as I speak now, which I'll finish off, and you should get an embodiment of what equity means. And I'll read the definition for you from Black's Law Dictionary. It says here, in its broadest and most general signification, the term denotes the spirit and the habit of fairness, justness, and right dealing, which would regulate the intercourse of men and with men, the rule of doing to all others as we desire them to do to us, or as it is expressed by Justinian to live honestly, to harm nobody, to render every man his due. It is therefore the synonym of natural right or justice, but in this sense its obligation is ethical rather than jural. Okay, I read that again. It says, but in this sense its obligation is ethical rather than jural, by a court, in other words, and its discussion belongs to the sphere of morals. It is grounded in the precepts of the conscience, not in any sanction of positive law. In the restricted sense, the word denotes equal and impartial justice, as between two persons whose rights or claims are in conflict. Justice, that is, as ascertained by natural reason or ethical insight, but independent of the formulated body of law. This is not a technical meaning of the term, except insofar as courts which administer equity seek to discover it by the agencies above mentioned, or apply it beyond the strict lines of positive law. So I hope that defines equity in a much deeper meaning. Effectively, it is fairness, okay? One man says that equity is behaving in such a way that is morally upstanding. So hopefully the picture is now being presented in a better light. So the question, I can understand how equity can fight your case, but doesn't the final decision lie with the judge or jury? The final decision lies with the judge, but you got to understand that the claimant or the beneficiary should always win. So providing you can always prove your trust, there's no reason for you to lose in equity. So when we talk about litigation tomorrow, your job is to just limit a judge's discretion, that his decisions are in favour with your argument. And so if you don't understand the law, you won't win. If you don't understand how to formulate a trust and prove a trust, you cannot win. If you can't understand how to get the court from common law into equity and invoke equity in its purest sense, you can't be heard in court. So this is why I'm saying it's simple, but it's not easy. All right? So I hope that answers your question, Kenny. Right, okay. So, and let's continue with this text here, because it's really important for this evening. Where did I get to? Right, okay. So it says here, I'll just repeat. I might be a bit repetitive, but I apologise here. The Chancellor eventually became the head of his own court, known as the Court of Chancery, and it was here that equity developed as a branch of law, distinct from and at times in competition with the common law. The Court of Chancery came to be associated with discretionary, almost ad hoc justice, whereas the common law courts came to be associated with certain rigid and inflexible forms of action and remedy. And in his speech in the Earl of Oxford's case, which is a very powerful case, okay, it's back in 1615 now, all right, Lord Chancellor Ellesmere observed that the office of the Chancellor is to correct men's consciences for frauds, breaches of trust, wrongs and oppressions of what nature soever they may be, and to soften and mollify the extremity of the law. In that case, the Lord Chancellor was defending the Court of Chancery from the accusation made by a gentleman called Sir Edward Coke, who was then the Chief Justice of the Court of King's Bench. Today we have a Queen, so it's called the Queen's Bench, which is the division of the common law today. Okay, Chancery is the division of equity in the High Court, and then the Queen's Bench is the division of common law today. Okay, so that it had illegally assumed the role of Court of Appeal over the common law courts. The Lord Chancellor's sophisticated response was to argue that he was not criticising common law judgments, but rather the conscience of the party seeking to enforce those judgments, which is quite clear that the conscience of the judges we deal with today is not for your benefit at all. So equity will come, and when I go through the maxims, it will make more sense, but equity will come to your aid, providing you've done all that you're supposed to do. All right? So another question. So sorry, Richard, was you quoting from Gary Watt's Trust and Equity book? That's correct. I'm currently quoting from his book, and it's a phenomenal book. He's one of the better authors with regards to equity that I've come across. Is it inevitable to go to court when using trust, or can you use them and not get drawn into court battles? Depending on the party that you're dealing with. It really does depend on the party that you're dealing with. To be honest, when I'm dealing with trusts today, I'm normally getting involved when it's already gone to courts. So effectively, if the examples I gave yesterday, it stopped court actions. All right. So unfortunately, what I'm trying to say with, I don't think it's not time for us to be afraid of court. Depending on your circumstances, not everyone on this webinar has debt issues where it's going to court, but you got to understand. I mean, just for some stupid water bill of £200, they may try and put a charge on your home. They may try and put a CCJ against you. Now, sometimes you can't avoid that. You just cannot avoid it. Now, you can, if you don't know, if you just come on a call and you have no clue about promissory notes or A4Vs, this is completely new to you, and you know you've got court cases pending because you've been in ignorance or silence or suffering and not knowing what to do, then we're going to have to get some action, to take some action and do something fast. If you've been in, not taught by myself or whatever, I don't know, but you've just been rummaging around trying to find knowledge, information, understanding to deal with these people wisely, and everything you've done in the past has just not worked, then if court is pending because they use court for their own gain, at the end of the day, you're going to need to know how to fight that system. You can't really get away from it if you're going to be going down this journey. So either you stay in their world, pay their bills when they want you to pay, and that's fine, and you've got no problem with that. If you have a problem with that, then this is what this course is all about. We can't really negate it. But just choose your fights, pick your fights wisely. If you're aware you can OID certain things, so maybe you just want to pay certain things at OID. That's not a problem. There's certain things that just for a matter of principle, you're going to have to get involved. Someone just takes you to court, no matter what you do. You may not have 60 or 100,000 pounds to pay somebody before you can OID it, so you're going to have to fight them. It just depends on what fights you're going to pick and what fights you're going to choose to get involved with. Yeah. What stopped court actions? I don't know if you were on the call yesterday, but when I told my story, the very first trust I expressed, and that was a year ago, stopped council-tax harassment. It stopped a statutory demand for bankruptcy, and it stopped a county court judgment being made initially. So at that point, I realised, well, trusts work. So hence I studied, and now I'm showing you why it does work. There's not just an element of truth. It's not just people saying, well, I got this result as a one-off. It's repetitive. You can repeat this, and you can see why it works, which is the beauty of trust. You can see it because you can read it in their law books. You can read it in their statutes. You can read it in their policies in case law, and you now have credible proof and information to get justice, as long as you're prepared to fight. Yeah, I agree with you, Nana. I'm not saying that just because you get involved with trust, you by default you get involved with court. But I deal with people who have court issues, and I deal with people who don't have court issues. You may just want to use trust to protect your assets, and that's it. You may want to use trust to pay certain bills, and that's it. But at least you know the end before you get involved with the beginning. That's what I'm trying to say. And normally, because it involves a litigation stage, if you're winning pre-court, you're less likely to go to court if you've done what you're supposed to do correctly. Or they may try it on because they know that people don't like court because of the fear aspect, and that's why people just give up. So that's all I'm saying about it, really. It's not a matter of, well, we have to go to court. I'm just trying to teach you where this has stemmed from. All right, there's two bodies of law. The best learning place for this journey is court, because more than likely they will test you, which is absolutely correct. I agree. And most of my learning, unfortunately, has come from, when you come out of the courtroom and you review what just happened there, and you realise, okay, I can see why. And it gets you thinking, it gets you researching, it gets you, and then I can now teach you, because I've been there, done that. It's not just a matter of just sitting down and reading books for the sake of it. It doesn't work like that, in my experience. So the book I'm reading from is just, I'll write it down, just for those who've just joined the call. it's actually it's got Todd and Watts, 8th edition. Cases and materials on equity and trusts. All right, but the author is actually Gary Watts. Okay, so right, I'll have to that's a, if you can send me a private email on that one, Carol, then we can have a discussion on that one. I won't mention it on the group, if that's okay. Just send me an email, we can have a discussion on that. Right, so moving forward, I'm going to finish this off before I answer any more questions now, because time is going. But this part does bear repeating. So again, in his speech in the Earl of Oxford's case in 1615, Lord Chancellor Ellesmere observed that the office of the Chancellor is to correct men's consciences for frauds, breaches of trust, wrongs and oppressions of what nature soever they may be, and to soften and mollify the extremity of the law. It says, in that case, the Lord Chancellor was defending the Court of Chancery from the accusation which is made by Sir Edward Coke, who was then the Chief Justice of the King's Bench. It had illegally assumed the role of court of appeal over the common law courts, and the Lord Chancellor's sophisticated response was to argue that he was not criticising common law judgments, but rather the conscience of the party seeking to enforce those judgments. When a judgment is obtained by oppression, by wrong, and of hard conscience, the Chancellor will frustrate and set it aside. Okay? Not for any error or defect in the judgment itself, but for the hard conscience of the party. It just reminds you of the scripture of Luke 18 with the unjust judge. The woman just kept him, you know, he was hard, he didn't fear man nor God, the Bible says. And yet, so this woman got her justice because she was persistent with him, that he favoured her. Now, this is the same thing. It's saying the exact same thing as far as I'm concerned. Equity will come into the fore. All right, and then that scripture goes on to say men ought to pray and not to faint. And if you understand the definition of prayer, it just means petitioning to God for him to come into your aid. So the same thing here, equity will come to your aid if you allow it to. So you got to understand what this is all about. I'll give you a modern example of equity. I think it was Ryan Giggs must have had some affair or something like that, and this girl was about to go on the paper and reveal all. And he effectively gets a gagging order against her. He effectively goes to court and gets an injunction to stop her from talking. And the news on TV is saying, no, I can't believe these things still work today. What do you think Ryan Giggs went and done? Do you think it was a regular court that just gave a judgment? No, an injunction is equity. And to prevent his, or preserve his rights, or prevent a wrong from happening, yeah, even if he was right or wrong, it's still his private affairs. And so he got an injunction. Equity now prevented her. If she violated those rights, she'll be going to jail. So it's as simple as that. That's just a modern example of how equity will come to your aid. Now, okay, fine, he's got the money to invest in the expensive barrister to do it quickly, but there's nothing stopping you from learning and applying the same thing. All right? Right, some questions have come up. I'm going to finish this. I'm going to finish reading this and I'll answer the questions. I have to, because I know I'm going to not ever get it done. Right, so right, the dispute between Sir Edward Coke and Lord Chancellor Ellesmere was referred to King James I, the one who wrote the King James Bible, by the way. Okay. And the king who patronized the Bible translator quoted earlier in 1616. King James decided in favour of the Chancellor and thereby established the rule that whenever equity and law conflict, who would prevail? Equity shall prevail. Equity will have the precedence. Equity shall lead. Equity is in control. Why? Because the king wanted to reserve his right for having a conscience and not allowing any law to subvert his power conveyed to him by God himself. That's how powerful equity is. But most people don't actually understand that. I'll read it again. The dispute between Sir Edward Coke and Lord Chancellor Ellesmere was referred to King James I, the king who patronised the Bible translation quoted earlier. In 1616, okay, King James decided in favour of the Chancellor and thereby established a rule, which we now know as a maxim, okay, that whenever equity and law conflict, equity will prevail. A few years earlier, Shakespeare had set a similar scene before King Lear in the eponymous play. To Edgar, the king says, "Thou robed man of justice, take thy place," and this suggests the office of Lord Chief Justice. To the fool he says, "And thou, his yoke fellow of equity, bench by his side." This clearly indicates the Lord Chancellor, and then William Shakespeare in King Lear, and that's Act number 3, Scene 6. So this scene, which appears in the 1608 quarto edition of the play, was omitted from the 1623 first folio edition. This guy's gone deep into his research. They don't want you to know this stuff. It says the omission is probably attributable to the fact that the relationship between law and equity had become so politically contentious around that time of the Earl of Oxford's case in 1615. So I want to stop there, but just a quick point here is that equity necessarily has a place in any just system of law and is not exclusively an English idea. Nevertheless, it is only in England, with its peculiar jurisdictional distinction between the courts of common law and the court of chancery, that equity enjoyed, or depending upon one's point of view, endured gradual refinement into a distinct body of law that has survived until the present day. And I say endured because the process of developing equity in the special court of a chancery was a long and painful one, and by the start of the 18th century the Court of Chancery was hopelessly overworked and inefficient, to the appointment in 1729 of the Chief Chancery Master, the Master of the Rolls, okay, to sit as a second judge hardly helped, mainly because the Chancellor remained the only judge able to hear appeals, and in 1813 a Vice-Chancellor was appointed, but even that did not improve matters much. There were now 3 judges presiding in Chancery, where once there had been the Chancellor alone. Now there were 3 judges. It says, yet when Sir Lancelot Shadwell was asked whether the 3 judges could cope, he is said to have replied, no, not 3 angels. And the Court of Chancery Act 1851 was an early attempt to wrestle with the procedural problems in the Court of Chancery. Now, I'm reading this because this is vitally important for you to understand. It says, it was during 1851, when the newspapers were full of talk of Chancery reform, etc., that Charles Dickens wrote his great literary complaint against Chancery, which is called The Bleak House. But the Court of Chancery and the common law courts were subsequently fused as a single Supreme Court by the Judicature Acts of 1873. Now, I've said that because this is going to lead you into enforcement and also lead you into, for tomorrow's webinar, where we talk about litigation. Right now, you've got one court, which is the High Court, and all the rules. There used to be 2 separate courts. There used to be a separate Court of Chancery, where it is today, and the bench, the Queen's Bench or King's Bench, was in Westminster. Sorry, other way around. Chancery was in Westminster, and the Queen's Bench or King's Bench was in where it is today in the Strand, and they joined both bodies together. It's in the one court today, and the rules to get into equity, as well as the rules to get into the common law, were fused and merged into one, which we now know as the CPR rules. Okay, so you need to understand that equity is there for your aid, but if you don't know how to find it or invoke it, it will not come to your rescue. All right, and that, I just wanted to read that for an introduction, and to tell you now that equity exists. Equity is the law that governs trust, and you have no say as a beneficiary, especially when you go to a regular court, if you go to a regular court. Now let's look at, I'm not going to talk about anything more about court, hopefully today. I'm going to more about that tomorrow. Today now is why is equity so powerful, and how do you enforce your trust? Well, we're going to look at now what we call maxims, and there's 12 principal, what we call core maxims. I'm going to read them out to you. Have we got? Oh, I'm just read these questions first. Was just looking at the book in Blackwell's today. Okay, what is your Skype group? I'm not too sure about that question, Agnes. If you've already done one of the trust courses, which of these new ones should one do? It will be enforcement, and the last one is the litigation. All right. The quote regarding Shakespeare is in the Todd and Watts book that you've got written up now. That's correct. Absolutely correct. Yeah. So, Heather, you just come back. Just to answer your question. It's the enforcement course and the litigation course that you'll be interested in if you've done the basic one already. All right. Right now, maxims of law. Maxims of law. I'm going to read them out, and I'll try and write them out as well. There's 12 core. I've got 19 here, but there's 12 core maxims. And I'm going to go through. I'm not going to explain it into too much depth because that will take a long time, and I might even start preaching, which I don't want to do. But I'm just going to let you know that your comfort in enforcing your trusts lies in these maxims. Okay, and the maxims is known as legum legis. All right, the law of the laws. Yeah, it's the principle. It supersedes any statute. In fact, they couldn't introduce bills, acts, and statute without equity. That's why you have to vote. It's as simple as that. Now, number one, equity regards in what ought to be done. Okay, equity regards what ought to be done. Equity will not suffer a wrong to be without a remedy. Just those two maxims alone is the principle of all equity, to be fair. Okay? Equity delights in equality. One who seeks equity must do equity. One who seeks equity must do equity. Equity aids the vigilant. This is my favourite one because it affects me the most. Equity aids the vigilant and not those who slumber or sleep on their rights. Yeah? It's as simple as that. It will aid the vigilant, those who are persistent, those who are looking for justice. It will come to your aid, and not those who sleep or slumber on their rights, okay, and gives up and quits easily. Equity imputes an intent to fulfill an obligation. This is where your trustees will be scared, because it will. The word impute means it will make you, it will force you, it will enjoin you, yeah, and compel you to act in order to fulfill the office that you are obliged to perform. Equity acts in personam, not in rem. What does I mean? Has anyone heard of these two terms, in rem and in personam? Has anyone not heard of these terms before? Would you like me to explain them in a little bit more detail? Type a Y if you can. Yeah. All right. Okay, that's a few years coming up here. So, in rem is Latin for against a thing. Okay, so when you go to court in common law, what do? They pass judgment against you to do something, normally to pay out money, and if you don't pay out money, they're coming against not you but your things. They'll take your house, they put a charge against your house, they'll take your car, they'll clamp your car, they'll do all that kind of stuff. Okay, that's effectively what in rem means. Yeah. Whereas in personam is they don't care about what you own or your strawman own. They're coming after you. That means jail time if you don't do what they've ordered you to do in personam. So a trustee who is in breach or has not performed and is found guilty of that, and that's why typically when you go to court as a defendant, if you haven't paid, that's it, you're guilty. They don't care about anything else. They're coming after, in equity, they're coming after you. All right? And that means jail time if you don't fulfill the order. So that's equity acts in personam. All right. And plus the reason why I'm saying that is it's only you or a man. When I say a man, a real living person has a conscience to deal with. Yeah. Only they can act unconscionably towards you or not. So equity has to correct that unconscionable nature to be conscionable. So it only can work against the person and not the thing. It has to compel the person to perform, and that's why it says equity regarding what ought to be done. It reverts back to that, yeah? So equity abhors a forfeiture. All right, number 9, equity does not require an idle gesture. Number 10, one who comes into equity must come with clean hands. And then the common law opposite to that is the unclean hands doctrine. So they're two separate things, okay? So equity delights to do justice and not by halves. Equity will take jurisdiction over a multiplicity of suits. So if you've got a multiplicity of actions going on, equity will just look at the whole thing and just make one decision. It's not going to allow certain multiple suits to go on and not deal with the problem. It will deal with the problem, okay? Equity follows the law. Equity, I'm not even explaining equity follows the law. It's not how it sounds, in other words, okay? Equity will only follow the law if the law is correct. If the law is operating unconscionably towards you, equity will take precedent and correct the wrong. Equity will not aid a volunteer. In other words, if you're not operating in trust, it doesn't want anything to do with you. You're back in common law. Number 15 here, it says, between equal equities, the law will prevail. Number 16, between equal equities, the first in order of time shall prevail. Okay? Equity will not complete an imperfect gift, which is not really the truest form of maxim, but it's on here anyway. Number 18, equity will not allow a statute to be used as a cloak of fraud. That's very powerful. They're hiding behind all these statutes to justify things, and it says it will not allow a statute to be used as a cloak of fraud. All right? And number 19, equity will not allow a trust to fail for want of a trustee. So I've got a couple of questions. Explain clean hands, okay? And what was the one before equity follows the law, please? Equity will take jurisdiction to avoid a multiplicity of suits. All right? So clean hands. Explain clean hands. Right, okay. In other words, equity... what's the easiest way I can explain clean hands? Equity, one who comes to equity must come with clean hands is, in my mind, the same as he who seeks equity must do equity. If you've entered into a contract that states you must pay, and you haven't paid, and yes, you're going to equity for help, you've violated the rules. So equity is not going to come to your aid if you haven't paid, because you've promised that you would pay. That's the contract. So you must come into equity with clean hands. So in other words, you must have done everything that you can do in your power in common law, so that if common law is still dealing you a bad time or a hard blow, equity will see that you have been equitable, so equity will come to your aid. All right? There's quite a few parables. There's one on here where it says, "He who seeks equity must do equity." Matthew 7:12. Therefore, whatever you want men to do to you, do also to them, which is putting it bluntly. All right. And then where's the other one was there's a parable of the creditor and his aid or his servant. Not his servant, but basically someone came to the creditor asking, pleading for mercy. I can't pay the debt. Please have mercy upon me. Give me some more time. So the creditor had favor upon this guy and said, fine, no problem. I won't put you in prison. You can have more time to pay the debt. But then some other debtor came to that same person who was now relinquished of his debt, okay, asking for mercy, but he didn't deal the same blow. He said, no, you're going straight to prison. So the creditor goes to this guy, look, I'll give you favor, I'll give you more time. And yet, so the same guy who got the favor, someone else asked him for help and he refused it. So the creditor came back to the guy and put him in prison because he who's seeking equity was not doing equity. He had unclean hands. So the question now, but if the other side has less clean hands, are you equitable? Well, it's not about the other side, it's about you. Have you fulfilled what you said you're going to do? Have you fulfilled everything you're supposed to do? Equity will come to your aid. All right? So that's how I see it. So if they're dealing a bad blow against you, that's fine. But the question is, if you want equity to come to your aid, have you done everything that you're supposed to do? Else it can't come to your aid. So that's the equitable part. In common law, it's that you can't come in with unclean hands. So it's just a kind of a balanced type of thing. Have you paid the debt, etc.? That's why when we talk about the trust yesterday, yeah, the trust has paid the debt. The trust has paid the debt. Now the question is, only in equity will it be recognised if the trustees have not performed their duties? So long as you've done your part, then that's fine. But if you haven't fulfilled, this the same thing with in when I say DC or debtor creditor world, it's the same thing. Where they're arguing and saying, well, prove the debt, validate the debt. Well, that's a worthless argument to get into. You're never going to win that argument. You're better off saying, well, look, I paid you now, and the whole script has now flipped across because they can't define what payment is to you. All you know is you fulfilled the obligation. They can't tell you what species of money to pay in because there is no law to determine what species of money to pay with, and plus there's no money anyway. So therefore, you've got the upper hand, and you fulfilled your part of the deal. You've paid. So equity should come to your aid. All right. So that's why you've got clean hands, because you've done everything you're supposed to do. So he who seeks equity must do equity, and that is the underlying statement for he who comes into equity must come with clean hands. So you're not acting unconscionably towards your adversaries. That's why Jesus said, "Love your enemies." Yeah, because even though it seems like an oxymoron, he's just saying, look, it's the one thing for them to give you a bad time, but if you're going to give them a bad time, then how can I come in and give you justice? It doesn't work that way. So I hope that explains it. That's the best I can do for a very, very short space of time. But if you haven't met your bills and incurred a debt, you have unclean hands? Exactly, you do. But if you've expressed the trust and paid the debt, then your hands are now technically clean once you prove the trust. Or if you've used other methods in the past, which pre-trust methods, again, you fulfilled your obligation. That's the point I'm trying to make. Pay the debt, pay it off. All I'm saying is you don't have to use your hard-earned labour and cash to pay it with. All right. So I hope that answers the question, Kenny. Okay. So these are the equitable maxims, and this is what we use to enforce the trust in it, because you effectively equity will come to your aid. What I want to do now is draw your attention to certain situations where equity will be invoked, and then we're going to just close by talking about the types of equity. I know it might sound a bit confusing, but there are actually two distinct types of equity, and you need to know what side of the fence you're standing on. Okay, so let me just get the correct. Right, here we go. Is this helping everyone, by the way? Is this okay? No one's not fallen asleep or switched off or anything like that? Is this within your expectation, or is it superseding your expectation, or is anyone indifferent? Is this helping? Okay, cool. Right, so I'm now reading from a gentleman called Henry Gibson, a treatise on suits in chancery. This is one of the books that we use in the enforcement side of things. Well, in fact, from enforcement and litigation. Huge book, but there's a section here which I want to read out now called "The 33 Children of Equity." And what I find really exciting about this is that when I read this and understand these proponents of equity, 100 and 200 years ago, especially in the States where they brought over UK law, and so it's almost repeated from what we're seeing in the UK itself. Well, now when you read their rules, it's purely equitable. everything, I know it might sound like a joke, but it is actually purely equitable. If you read their law books, you know, the Green Book, you read CPR rules, you understand what they're trying to achieve, even something like pre-action protocols in the courtroom, and you look at that, it's purely equitable. The doctrine of notice is purely equitable. The doctrine of evidence and specific performance to compel evidence to be produced. This is a simple giving a defense to a claim and then expecting a reply to your defense or a counterclaim. All of this is purely on an equitable nature, and they're just using it against you, but in a general form. So all we've got to learn to do is recognize equity. We talk about opening your equitable eyes now, seeing what they're trying to do against you, and then stopping it or subverting it or countering it with your own attack. The whole premise of equity is unlike anything I've experienced before, because normally I'm on a defense if I'm in the debtor creditor world. You know, they're making an accusation against me and I'm just trying to push them away and leave me alone. In equity, you are actually bringing the fight to them. You're the one who now saying, look, I've had enough and I'm going to come after you, so you better get ready. And believe it or not, who do you think in a trust relationship is the one that brings the fight? Out of the 3 characters in the role, it'll be interesting because some of you may have been in my courses, but most of you, there's about 30 odd people on the calls tonight. So it'd be interesting to find out your understanding of what I've said so far. Out of the 3 roles, the settlor, the trustee, and the beneficiary, who do you think is the one that brings the fight to prove a trust and to compel someone to act? So I've got one answer. If you can all type something, okay. So some saying the trustee, some saying the beneficiary. Anyone else wants to attempt to answer? Okay, right. So most people are saying the beneficiary. So obviously people got some background of trust, which is good. But or declines, who responds? Okay, Dory, could you just repeat the question? So Benny, but when the trustee disclaims or declines, who responds? Well, if for the disclaimer, the trust has invested. If the trust has invested, then the settlor is still in the picture. So it's the settlor that will make sure the trust is vested. Once the trust is vested, if the trustee is not performing, the one who compels the trustee to perform is the beneficiary. All right, the beneficiary is the one who compels the trustee to perform. If the trustee is disclaimed, it means that the trustee is not vested yet. So it's a settlor he will compel. And remember, a trust will not fail for lack of a trustee. So, but you don't want the court to get involved with your trust. So you will find a trustee. So the trust is vested, but trust denies who the beneficiary is the one who enforces, or the trustee, depending on the setup. So if you've got multiple trustees and one of them has a good conscience and sees that the others are not behaving themselves, then that one can compel, or the beneficiary brings it in to courts. However, a beneficiary cannot be heard in common law because he hasn't got no legal status. He only has real equitable status. So he only can be heard in equity. He has an equitable claim. And those are very powerful words, equitable claim. And by the way, a county court can hear equitable matters up to £30,000. So you can invoke a court of equity at any time. But we're going to talk more about that tomorrow. Let me not get distracted too much here. So I want to just talk to you about the 33 children of equity. So it will open your eyes as to you have equitable rights. This may start to be quite eye-opening for most of you here. And again, all of these are surmised in the CPR rules. All right? Just to let you know. It's in their statutes and acts. It's all, coded. It's all codified and hidden. But it's all there. And they are very distinct to the when they talk about legal aspects and lawful aspects. They don't mince their words at all. So a quick question. Would equity be on your side in a student, in any case? But let me read these 33 children and you'll understand, okay? Okay, the equitable or inherent jurisdiction of the Chancery Court includes all cases of an equitable nature where the debt or demand, now this is an old document, it says exceeds $50, but this now just assume it exceeds any amount, all right? And these cases include the following. Number one, all suits resulting from accidents and mistakes. Number two, all suits resulting from frauds, actual and constructive. Number three, all suits resulting from trust, express, constructive and resulting. All suits for the specific performance of contracts. All suits for the reformation, re-execution, rescission and surrender of written instruments. Okay? All suits for an accounting or for surcharging and falsifying accounts. All suits for partners and to wind up an insolvent partnership. All suits for administration and marshalling of assets. All suits for subrogation and substitution, which is basically insurance. All suits for the enforcement of liens created by mortgages, deeds of trust, sales of lands on credit, or other equitable considerations. All suits by married women against their husbands, except for divorce. All suits against married women and minors in reference to their estates, not cognizable at law, common law, yeah? All suits by wards against guardians. Wards against guardians, that's the straw man, okay? Guardian-warder relationship. Executors, administrators. Just turn the page here, sorry. And others where an accounting or surcharging or falsifying an account is necessary. All suits for the apportionment and contribution. All suits for the marshalling of securities. All suits for relief against forfeitures and penalties. Yes? All suits for the redemption of land or other properties. So all mortgage cases are equitable ones, by the way. All bankruptcy cases are in equity, okay, governed under chancery. All suits to have absolute deeds or bills of sales declared to be mortgages. All suits for the construction and enforcement of wills and trusts. All suits to obtain a set-off against a judgment in favour of a non-resident or insolvent. All suits for the discovery or perpetuation of testimony. All right, discovery is equitable. Has anyone heard of discovery before? You know, discovering the truth, what actually happened. Yeah, just by writing your proofs of claims is discovery. You're getting the evidence, but we'll talk about more of that tomorrow. It says here, all suits to compel complaints to interplead. All suits for equitable attachments and receivers. Okay, that's with LPA receivers. All suits where a ne-exact republican, that's a type of injunction, is sought. All suits where an injunction is a substantial part of the relief sought. All suits to remove clouds and quiet titles. All suits for the establishment and all suits for the establishment and execution of charities. All suits of a new trial after a judgment at law. All suits to have void judgments so declared and to avoid voidable judgments. All suits to execute decrees and to impeach decrees and judgments. All suits to prevent the doing of an illegal or inequitable act to the injury of complainant's property rights of interest, okay? All suits for the exoneration or protection of sureties. And number 33 is all other suits where the defendant has done or is doing or is threatening to do some inequitable acts to the injury of the complainant and there is no adequate remedy thereafter in any other court. So to answer your question, equity will be at your aid for pretty much any commercial situation that you will find yourself in today. Or should I say your straw man will find itself in today. So you need to understand that yes, trust is very powerful, but you also need to understand why you're establishing them and how to enforce it. And so with the maxims, it opens a doorway to say, well, yes, I'm going to enforce my rights because you have rights. Remember, he who is equity only aids the vigilant and not those who sleeps on their rights. So once you understand that you have rights, you've got to do something about it, and equity will come to your aid. And so that's the crux of enforcement. So once you understand that you are in equity, now there is a difference between when you go to the county court. Yes, they're operating in equity against you, but it's stuff that they've made up. It's all constructive. All right? We talked about construed trust. Everything's pretty much a construed trust. The fact that you've got a straw man is constructive. Until you express what you want to see. Remember, you are the owner of everything. Okay? You rule. You own. As real men and women, you are the possessors of this earth. Okay, and so therefore it's your responsibility to be aware of your rights, and no one can tell you because you've already been told. So what you got to understand is, now that someone said something to you, I've noticed you of your rights. The question is, are you going to get up and find out what they are, or are you going to just say, "Oh, no, not to worry, too bad. It's already been done. I'll let them just have their way, and I'll just fit into the system like a glove and live at peace." Well, that's fine, but you won't be living at peace for that much longer. Trust me. So you might as well fight for your freedom now rather than waiting until it's too late. So all I'm trying to say to you is this: as a settlor, as the real man, you have rights. I'm trying to help you establish what they are. You need to own this information as best as possible so you can apply it. You can utilize this for pretty much any situation or circumstance. I can't say here and make guarantees. I'm not in that position to be making you guarantees. The only thing I can guarantee is that equity is real and it works. Trusts are real and it works. So the only thing that limits you from your from where you are now to victory to what you want to be is just what you know and your ability to apply it. And the only way you're going to get to do that is by studying and getting knowledge and getting to a place where you can accelerate your learning to deal with these people fast and quickly. But what I love about Trust is that I'm reading all these books I've got around me are just law books. They're law books, which I can read and open my eyes of understanding so that I can see what's going on and use it against them. And they have to shut up because it's in writing. And this is what I never understood before early on in my journey. You used to go there and talk in the courtroom and they'll just make up their stories. And we're thinking, hang on a minute, the judge is just railroading me, he's just doing what he wants to do. He's doing it because he can. But you can limit that once you know who you are. That's the beauty of it all. So there is, what I want to close with now is you have to be in what we call an exclusive jurisdiction. All right, what the book would call inherent jurisdiction. So if you haven't been able to keep up with your bills, would that mean that under the maxim about dirty hands, or clean hands rather, you can no longer receive equity? I'm saying equity won't come to your aid unless you have done something that's equitable. It's let me answer it like this, because it's not here to make people feel that they're in some form of persecution or under subjection or they've lost hope. Because I've just said that equity aids the vigilant. So let's I want to read something to you, and hopefully this might make life a lot easier. If you just bear with me for 2 seconds. Where are we now? Sorry about the silence, just came to me. Basically, I wanted to read something. I'm just trying to find it to read it to you. No, it's not. Okay, I'll have to just tell the story from my own point of view. There's this a scripture which I wanted to read out, but effectively, it was time for Peter to pay the tax in the Roman system. Okay, bear in mind that we're in a Roman system today. And so the tax collector says to Peter, does your master, Jesus, pay taxes? So effectively, Jesus says, overhears a conversation, and even before Peter enters into the room where Jesus was situated, Jesus asks Peter a question, and I'll read it out here. I'm reading from Matthew 17. And I'm going to start the story. So it says, when they were going about here and there in Galilee, Jesus said to them, the Son of Man is going to be turned over into the hands of men. And then verse 23 says, and they will kill him, and he will be raised to life again on the third day. And they were deeply and exceedingly grieved and distressed. Now when they arrived in Capernaum, the collectors of the half shekel, which is a temple tax, went up to Peter and said, does not your teacher pay the half shekel, which is the tax? And he answered, this is Peter, yes. And when he came home, Jesus spoke to him, that's Jesus spoke to Peter, about it first, saying, what do you think, Simon Peter? From whom do earthly rulers collect duties or tribute? All right, or collect taxes, okay? From their own sons or from others not of their own family? And then verse 26 says, and when Peter said, from other people not of their own family, Jesus said to him, then the sons are exempt. All right? So let me read it from the King James translation. I'm reading from the Amplified just there, but the King James one says like this. It says, Peter said unto him, of strangers. So, verse 25, and he said, yes. And when he was come into the house, Jesus prevented him, saying, and he says, what thinkest thou, Simon Peter, of whom do the kings of the earth take custom or tribute or tax? Of their own children or from strangers, right? Now notice, kings of the earth are you and I, the real men, the real men and women, okay? Not these straw men. The kings of the earth are you and I. Who is the one who's supposed to be paying taxes? The family members of the kings of the earth, or the sons, yeah? Or the strangers, the one who's outside the family? Then Peter said unto him, of strangers, Jesus said unto him, then are the children free, okay? In other words, the children are free from paying any tribute or taxes at all. But then he says, notwithstanding, okay? Or he says, however, in order not to give offense and cause them to stumble, that is, to cause them to judge unfavorably and unjustly, he says, go down to the sea and throw in a hook, take the first fish that comes up, and when you open its mouth, you will find there a shekel, which is of silver. Take it and give it to them and pay the temple tax for me and for yourself. So, the full chapter is Matthew chapter 17, okay? Starting from verse 23 down to 27. All right? Now, the point I'm trying to make to you is this. You are the sons of, or the kings of the earth. All right? And you are exempt from tax. That's why it's called a tax return, because the tax is supposed to return to you and I. Now, if you go on the OID course, I'll explain this in more detail. But effectively, you are the source of all the credit. You are the source of all of the energy, of all of the money that's going around in this world. And so, therefore, that can only be done today because of a trust. And 99.99% of the population do not know what relationship they are in. Okay? Even though the relationship has been corrected. If you don't know, in other words, if you're not vigilant, you sleep on your rights and you have none. So the point I'm trying to make is, you are the sons of this earth, or you are the kings of this earth. So you're not technically supposed to pay anything. But he says, lest they be offended. So irrespective of what the situation is, just pay it. So you are going to be acting equitably. Now, what I've just explained, if you are in arrears, if you have issues, problems, or whatever, I'm not saying you have to physically pay with cash. All right. In some circumstances, you may want to, because they may want to take your house, and you're just going to have to, lose this particular battle and live to fight and win the war. All I'm trying to say is, you've got options. You've got acceptance of value. You've got a promissory note. There's pretty much the two main ways of making payments outside of paying using the trust to make a payment, which is what we're talking about on this course. All right. So once you have paid and you can prove it, then you are in honor. And as far as you're concerned, as far as I'm concerned, you have clean hands. I hope I've made the point. You're just doing what you're supposed to do, and to stop any offence from being made. Now, it's these people who are coming against you who are acting unconscionably, because if you've fulfilled the obligation and they can't provide proof why you shouldn't pay with the methods that you have paid with, then it's no different to the example I've told you about, where if you give me £10 too much change and I don't say anything, or use their example, keep sending you harassment letters, keep sending bailiffs to your home, and keep causing you grief and messing up your credit file and all that stuff, they are acting unconscionably towards you. It's as simple as that. So therefore, equity is there to correct the wrong, because as I read out in the maxim, which is a guide to your ability to enforce, equity will not allow a wrong without a remedy, and there are multiple remedies, or what we call equitable reliefs, which I'll talk about more tomorrow, in equity. It will relieve you from the burden, from the pressure, from the pain. You get relief in equity, you get remedies at law. All right, so I hope that answers your question, whoever asked it earlier. Now, the next question here says, yeah, so Kenny, did that answer your question? I hope that, it's just breaking it down as best I can, really. If you haven't made payment, you're going to have to pay them. You're going to have to learn about A for V and all this stuff, and you're going to have to start to effect payment and do what you're supposed to do. That's our part of this bargain in this fictional world that we live in. It's as simple as that. And stand on it. So the next one says, okay, so just to clarify, what the actual trust is it fair to say that it is the straw man of finance? It's a fictitious person trust who is liable to foot the bill based on operating in a bankruptcy? Pretty much so, that's correct. It's a straw man who's the company, the conduit, the vehicle operating in this fiction, because we're too powerful to operate in it. But they're attaching everything to the straw man, so you're going to have to correct those records. And the trust is the most powerful way of doing that. Okay? So, is that okay for everyone? Just type a Y if I've not lost anyone at this point. No one's cut off the call, which is great. So, it seems like it's working okay. Right, so thank you for that. Thank you for your answer. So that's fine. So now just as I was finishing off, we have to operate in the equitable jurisdiction. This is where the relief will come, and they don't want you to operate in that world. Solicitors are not trained. I mean, it's only the high-paying ones that would have any kind of idea about trusts, but they're all versed in the at-law side of things. That they can't deal with your trusts, and they don't want to receive your trusts. And when you know what you're talking about, they may try to pick holes and call it peculiar and incomprehensible, but they're just playing games because they know what's going on, and they're just trying to, as my mum would say, play fool to catch wise. Yeah, they're just trying to play dumb. Well, you got to see through that. All right, you just got to see straight through that, and you got to be vigilant and be sober. Since I'm on scriptures, I can read another one. So you can. There's two. There's John 10, chapter 10, and it says that the thief, he comes to steal, to kill, and destroy. Yeah, the thief comes to steal, kill, and destroy. But Jesus says that he's come that you should have life and have it in abundance. So that's what I'm standing for. Why shouldn't you have it in abundance? And then 1 Peter 5 and 8 says it like this: be vigilant and be sober, because there's an enemy who's out there. Who is looking to devour you like a roaring lion. He will not sleep. He will not sleep. He's just trying to make your life a complete misery. So once you're wide awake and you know what's going on, unfortunately, you might call it karma, you might call it whatever. It's not. It's basically your eyes are now opened, and you've got to fight. You've got to stay above the parapet, so to speak. You're gonna have to be able to protect yourself financially. And trust is certainly a very powerful way of doing that. Another way to prove it is, why do the rich use it all the time? Why is it you can go bankrupt tomorrow and still live like a king? Because if you understand trust, the whole point of it is, it's not the one who owns it all, it's the one who controls it all. And that's what trust is doing. It's the one who has the control, is the one who's going to enjoy the benefits. So if, I remember there's a story that I don't know if it's true, but Warren Buffett was telling how he's supposed to be, well, he's a multiple billionaire, yeah, many times over, and someone wants to sue him because they're at a dinner party. You may have heard the story before, and for some reason his cat landed on was scared for some reason, and when it jumped, it landed on someone's legs, a lady's legs, and it scratched her legs quite poorly, or quite badly rather. So she wanted to sue him. So he's like, look, there's no point you trying to sue me because I don't have any money. I can't help you. There's nothing I can do. She didn't obviously believe him. So she wins the suit, obviously, but she can't get a penny from him. And why? Because nothing's in his name. Absolutely nothing is in his name. In fact, just a cat, which obviously she didn't want to receive that as a nice gift, but nothing was in his name. So he had full control, but he didn't own. And so if you're not a trustee, they can't attach anything to you because you're not recognized in their fictional world. You want to be the beneficiary because you have equitable rights. But guess what? You can't sue people for their goods and equity, and you can compel them to perform in equity. So you want to reside in the land of equity. You know, when you buy your gold and silver, you want to put it in trust. When things that you say you have an attachment or ownership of today, you want to put it in trust. Or if you have property, even if it's mortgaged, you can protect the equitable side of things by restricting people from putting their charges on there. Right. So that I'm just trying to tell you. Now I'm just going to close with one statement from a book, which again is from Gary Watts. I'm kind of giving away all my kind of trades, well, not secrets, but what I would normally give out on the course. But hey, you're here to learn, so be it. There's two quotes I want to read out to you. The first one's on equitable remedies, okay, which is going to be a nice precursor for leading into tomorrow. It says that the purpose of equitable relief is to do more perfect and complete justice than would be achieved by leaving the parties to their routine remedies at common law. This means that where the common law remedy is monetary damages, for example, as it usually is, the court asks itself, is it just in all the circumstances that a plaintiff, that's the claimant, should be confined to his remedy in damages only, i.e. money? One situation in which common law damages will often be inadequate is where there has been a trespass to land, or overhanging trees and overflying planes seldom can cause damage to landowners, and even if a trespass occurs at ground level, there may be no damage beyond the bending of a few blades of grass underfoot. It is because the common law has no adequate general remedy for trespass that the court will usually award an injunction, there you go again, against the particular trespasser. So it's acting in personam, that's equity acting right there. The trespasser who re-enters the land in breach of the injunction does not breach a rule, but infringes a prohibition issued against the trespasser personally and may be fined or imprisoned for contempt of court. Alright, so we just want to highlight, these are from law books I'm reading here, okay? And there's another one which might get your attention. Well, there's two more that I think might get your attention. This one's now it's called here Public Example and Private Equity. Alright? And it says, Lord Justice James once held that the trustee's fiduciary duties, which include the duty not to make an unauthorized profit and the duty not to put oneself in a position of potential conflict with the trust, must be strictly enforced for the safety of mankind. So if your trust isn't performing, it is your duty to compel them to perform. You have to enforce your trusts. This Lord Justice says here, for the quote unquote, for the safety of mankind. If you want the reference, it's Parker versus McKenna, 1874. All right, and now fiduciary means monetary duties. Right, so once held that the trustee's monetary or fiduciary duties, which include the duty not to make an unauthorized profit, which what do you think they're doing against you all the time? All right, monetizing your money in the background, okay, because of the general relationship that we have got to correct. All right. So that's unauthorized profit and the duty not to put oneself in a position of potential conflict with the trust must be strictly enforced for the safety of mankind. That's powerful words. And then finally, listen to this one. It says the English mortgage is a work of fiction, and it is a fiction of the dishonest kind. It says this was most apparent in the days when the mortgage operated by conveying the borrower's, which is the mortgagor's, fee simple, which is the we know as allodial or full title, fee simple to the creditor mortgagee until repayment of the debt, at which point the fee simple was redeemed by a reconveyance back to the borrower. The conveyance expressed in the mortgage deed was one which we call long suppressio veri, right? Now, suppressio veri is Latin for concealment of truth, yeah? And also suggestio falsi, which means a statement of falsehood. All right, so it says here that the conveyance, all right, that conveyance expressed in the mortgage deed, that one piece of paper which takes your property away from you, right, was one which is deemed as a concealment of truth and a statement of falsehood. And that is quoted by Justice Maitland, okay, in a book called Uses and Trusts. All right, so it's all in their word. It's all in their writing. Okay, and it says Maitland attributed the falsehood to the action of equity, but the legal deed of mortgage was inherently dishonest, for it pretended to convey legal ownership when the parties merely intended to create security for the loan. So, you know, and you continue to read that. Now, I wrote, this book is Equity Stirrings, okay? This is a book by Gary Watt. Again, as I said, this guy is a proponent of equity. I've not met many legal practice, and he's a reader at University of Warwick, okay? So, but he's a serious equity proponent, and this is like a real book of equity here, called Equity Stirring. Right, the story of justice beyond law. Right, so I'm going to finish up now. I'm going to go to 11:30 like last night. We've hit 2 hours now. So where we are now, yesterday I discussed about trusts and the law of trusts. Specifically to private trusts, express trusts. I'm not sure about that, Plamen. All I know, I've just got the ones that I've got. So I'm sure. I think the earlier one of the equity and trust should be fine because it's just really a new cover. So yeah, it should be fine. The context is still the same. The law, you know, the case law, there's nothing newer. They're all pretty much, 10 years and older. So it should be fine. Yesterday's, the videos take a long time to, what's the word I want to use now? To convert and then upload. So hopefully by tomorrow they should be ready for you to review or to watch if you missed it yesterday. So you need to kind of budget 2.5 hours because I was talking for that long. So we discussed number one about trust. Now today we've talked about enforcement of trust, and I hope you've opened your eyes a little bit into what we will learn. Obviously on these workshops I'm going to tell you about what you can do. On the courses I'm going to show you how to do it, the practical steps, so you can implement it immediately. Tomorrow now we're going to look more into the litigation side of things, which is the court, and how to prove your trust in the courtroom, and what law supports that, and also how to compel trustees to perform as well in equity. And then I'm going to basically, because the course dates are out, I think I sent an email yesterday, I've changed the dates because time's obviously going, so I've just given it an extra week. So the first private trust course, which is part 1, will be, I believe, I've put down for the end of the first week of April. That was the Easter weekend, I think it is, the Thursday and the Friday, which is this 5th and the 6th, I think, or the 6th and the 7th. I can't quite remember. And then the other course, which is the enforcement course, is the week after, and then the litigation course is the week after that. Both the private course is 2 days from 10 till 10, and the enforcement course is 2 days from 10 till 10. The litigation course is also going to be 2 days from 10 till 10, plus some webinar support for the drafting side of things, which we'll talk about more tomorrow. So please don't miss tomorrow, because it's vitally important. The standard costs of these workshops, I've had to increase the price because of my costs have gone up. So the standard cost is $695 per course for the 2 days. However, tomorrow, if you're still on the call, even if you can't make it because you've registered, you've taken the time out to take, to listen to me. You don't have to listen to me, and thank you very much for making your time available to do so. But because of that, then I will be making it a very special offer if you want to increase your learning. I know there's some people from abroad who are on the call, and so there'll be like downloads of audios from previous courses that you can get access to with the paperwork, perhaps, if that's something that you might want to be interested in. But either way, I'll give you the option. So if you can't make it tomorrow, don't worry. You will get the recording. I'll make the offer open for at least a day or two after the course tomorrow anyway. But the main thing is that you need to just stick it out till tomorrow if you can. I do appreciate your time. I do appreciate your attention. And the questions have been really great. I hope you are learning something new. I hope it is of extreme benefit to you, and it's not just listening to me in a soliloquy type of scenario. Yes, I'll be discussing that tomorrow, Kenny. There will be an offer for all 3 courses for those who want to take it all up at once. So please come on tomorrow. We'll finish up tomorrow. It's Friday night, so hopefully I won't take 2 hours on a Friday night. Maybe we're going to be chilling out and be with your family. But I'll definitely make it worth your while. And you can have access to these videos as well for future reference. So thank you so much for your time this evening. Have a good night, and I'll speak to you tomorrow for the final part of this course. Thank you very much indeed. Appreciate it.